What are the penalties for DUI in Indiana? Well, there's actually 4 penalties for getting a DUI in Indiana. The first one, there's an immediate license suspension. After that starts, then there's the actual criminal case that you got to figure out. And then if a person is convicted, there's a post-conviction license suspension. And then finally, after the case is done, there's actually Bureau of Motor Vehicle administrative issues. That includes SR 22, habitual traffic violator, points on a driver's license, and the fun to deal with proof of financial responsibility. So let's go through those pretty quickly, but we're going to take care of them. We're not going to rush through it. So back to the immediate license suspension. Now, this is right when you get arrested for a DUI. Now, the law says they're not supposed to suspend your license until the initial hearing, although some judges in the state like to jump the gun and do that before the initial hearing. Now, this administrative license suspension is only supposed to be activated if a person blows at or above 0.08 or the blood from their arm comes back at 0.08 or greater. There are a minority of judges in the state that say, no, we don't need chemical test results. We can do it if an officer just arrests somebody. So those judges are going to suspend it for 180 days, regardless if there's results back or not. Now, that's not even talking about a refusal. If there's a refusal, then it's going to be a minimum of 1 year. If you have a prior DUI anytime in your life, it's going to be 2 years. And that's not fun to deal with. There's other videos on that. Now, this administrative suspension at the beginning of the case, there is a law that says specialized driving privileges are allowed. So a person can drive to and from work. A judge has to sign off on that. And that's completely discretionary to the judges. So number one, if it's a refusal, you can't get specialized driving privileges. Number two, if you have a judge that says, I just don't give them, well, you're stuck with that judge. You can't get a change of judge because you don't like the way they deal with license suspensions. So that's the first thing we got to deal with. Now, the criminal case, what are the penalties for that? Well, the penalties for criminal case are all over the map. If you're a first timer, generally the maximum time in jail is 1 year. You're not likely going to go to jail for 1 year if you have a first time DUI offense, although jail time might come into play depending on if there's an accident, if there's a high rate of speed, if there's a very high blood alcohol content, if you have past criminal cases, even if they're not DUI, a judge can look at the past criminal cases. Also, if you're driving in a car with passengers, now we're not talking about kids or people under 18, because if they're under 18 and you're driving, that's going to be a felony, and that's going to be more problematic. But if a judge will look at all these things, passengers, prior criminal history, high BAC, speed, alcohol affects a person's judgment, so I don't see why a judge should punish someone extra hard for driving at a high rate of speed. Well, there's a reason why you're probably driving at a high rate of speed. You got bad judgment because you're intoxicated. So it doesn't really make sense, at least with my perspective, but I'm not a judge. Now, that's for first-time offenders. Now, if you're a repeat offender, if you have a DUI at any point in your life, and we do have some clients who are like, Mark, I've had a DUI since the 70s. How can they possibly use it against me? They can, and they will. So repeat offenders, again, all over the map. I'm going to go through this kind of quickly, so I'm not going to be offended if you got to pause and back up. If you have 2 or more DUIs within 7 years, that's going to be a felony, and that's going to be a maximum of 2.5 years in jail. If you have 2 or more outside 7, but within 10, that could be a habitual substance vehicular offender, which again, maximum time in jail is 10.5 years. If you have 2 or more outside of 10 years, but within your life, again, you might be back down to the maximum of 1 year in jail. But you got some judges that are like, I don't care if it's an A misdemeanor. They got to serve some time if they have prior DUIs. So the bottom line is the criminal penalties, the actual like imprisonment and whatnot, it's all over the map for repeat offenders. The common rules are that all courts treat repeat offenders much more harshly than first-time offenders, but there are some judges and counties that I would say are extreme in their harshness. It's very, very important that if you are a repeat DUI offender, you hire an attorney that, number one, is familiar with the county, familiar with the court, and familiar with the prosecutor, because even the harshest judges expect certain things to be done before you come to court because they want to make sure you looking like $1,000,000. And if you don't do these things, they're going to hit you even harder than they normally hit. Don't do that to yourself. Get someone who knows what the heck they're doing. I'm not trying to scare anybody, but with repeat offenders for DUI, jail is a very real and significant issue. Please make sure you hire an attorney who knows what they're doing and knows what they're talking about. So the third penalty of a DUI is if you're convicted, there's a post-conviction license issue. Now, the administrative suspension is only 180 days, and the maximum license suspension for a misdemeanor is generally 1 year, and the minimum is also 0. And all the time you did on the administrative suspension actually applies and counts towards the post-conviction suspension, unless you got a specialized driving privileges without an interlock. That's a little sidestep there. Now, the minimum is also 0 unless you have a prior, and the minimum is 1 year. And that 1 year can actually be shortened by agreement with the judge and the prosecutor, but it's also a possibility, and happens pretty often, that the BMV still catches that and imposes the minimum of 1 year. Okay, it's getting a little crazy. But then, so the maximum suspension is generally 1 year, but it can be 2.5 years if you have been convicted of a level 6 felony. And these years we're talking about don't start until and unless a person serves their refusal suspension. Remember, refusal suspension is 1 year if you have no prior DUIs, 2 years if you have any DUIs in the past, even 20 years ago. And those are separate and distinct from a conviction for DUI, and those suspensions are served before, so they stack. And those refusal suspensions, you can try to argue to get them shortened if a prosecutor will agree, or maybe a judge, or if you can actually do a refusal hearing. Refusal hearing is pretty hard. Again, not trying to make the license suspension complicated, but there's a reason a lot of lawyers don't even touch DUIs. And there's an even bigger reason why the lawyers that claim to be DUI experts mess up on the driver's license so often. The fourth penalty for a DUI is post-case issues dealing with the BMV. When somebody gets a DUI, they have to get SR-22 insurance when the pre-conviction suspension ends, or there's a conviction, whatever happens earlier. SR-22 is basically state of Indiana's way of making sure you have automobile insurance. On top of that, when you get a DUI or you're convicted, you're entered into this lottery where they're going to randomly select you to show proof that you had insurance on the day of the DUI. And it comes in a small little postcard or small letter. It looks like it's just a piece of junk mail, but if you don't respond to it appropriately, you get another license suspension. On top of that, DUI adds to the points a person can get on their driver's license. We all know when you reach that magical number, the BMV says, hey, your license is suspended because you're not a good driver. And then you got to take this driver safety course online to get those points down. Last but not least, right, it's not enough. There's something called the habitual traffic violator. And HTV for short, it's either a 5-year or a 10-year. If you have a DUI plus 9 moving violations all within a 10-year period, well, your license is suspended for 5 years. If you have 1 DUI plus 2 other DUIs or 2 other crimes involving a car within 10 years, so 3 within 10, you lose your license for 10 years. That's an admin suspension. A trial judge really can't prevent that from happening, but an experienced attorney can try to get you specialized driving privileges for that 5 or 10-year period. Okay, so those are the penalties for a DUI. It gets complicated. If you have any questions, give me a call. I love talking about drunk driving offenses. I love talking about how to fight cases and the best way to help people navigate these charges. If you have any questions, give me a call, 317-632-3642. And remember, always plead the fifth.